the state defendants.
Kaylee Watt for the district and Dr. Broby.
Fatima Rakabi for the WIAA.
Get everything. Thought we had set up.
No, she'll be handling counsel on behalf of the WIA, but I won't be arguing.
I thought it was more polite not to say something. That's what we chose to do, so you know. This is the first time I've ever had anyone tell us to switch.
Be the cruelest ever, but like the best anecdote for both of us.
But they're close. Okay.
I mean, it's at least something.
Okay.
You don't have to use it, but in case it helps, otherwise I'll just say, can we go to X, Y, it's just a slide in.
Mhm.
So, yeah, I'm gonna go you need a copy too.
Okay, good morning, everyone. Please be seated.
Good morning, Your Honor. Julie Blake. With me is Natalie Thompson, Hal Frampton, and Kate Anderson.
Good morning, Your Honor. This is Spencer Coates. We'll be speaking for the state defendants.
Kaylin Wett on behalf of the district and Dr. Gordon Broby.
Fatima Rakabi on behalf of the WIAA, joined by my co-counsel Mary Butler.
All right, thank you. Good morning to you. And I'm sorry, I have a list here of everybody's names, but I just want to make sure. So Ms. Blake, Ms. Thompson, and then who else did you say was with you on your side?
Hal Frampton and Kate Anderson.
All right, thank you, and good morning to all of you. First, let me just identify a couple of things. I'm coming off a summer cold, and so every once in a while I need to clear my throat. So my apologies if I maybe need to blow my nose or cough. I think I'm okay and not contagious, and looking at my staff here in the front, my apologies to you. That's one. Second thing is we're obviously dealing with issues that really get people going, very emotional type issues. And so I want everybody to feel, of course, that they're able to advocate on behalf of their clients. I want people to be respectful. At the same time, people are going to say certain things or phrase certain terminology. And one side or the other might feel they're offended by it one way or the other. Just know that I'm looking at everybody in good faith that they're trying to make the best argument on behalf of their clients. And so please try not to be offended because, again, for whatever reason, sometimes people take offense to how people phrase certain concepts or certain items. So with that in mind, what I'd like to do is first, let's talk about kind of what I classify as the preliminary issues. Standing, and then possibly a little bit about the Pennhurst notice issue, although I think the Pennhurst notice issue kind of bleeds into some of the other arguments when it comes to deliberate indifference and what is a known, alleged known violation or whatnot. So let's start off with standing, though, because I think somebody raised standing. I don't know who wants to go first on that particular issue.
I'll speak to that, Your Honor, on behalf of the plaintiffs. Should we go ahead and speak from the table? Or would you like me to
From the
podium?
dais here probably is best.
Certainly. So, Your Honor, the state has raised Article 3 standing. The other defendants have not. Their objection seems to be that it's not imminent that KM will actually be put in a position of wrestling a male in the future. That would be standing, an issue of standing for the parental rights claim and under 1983 and the athletic opportunity claim. We don't understand that argument to pertain to the hostile environment issue. She's there with that. Ms. KM is already will be back at school in 2 weeks and needs to be in a safe, non-discriminatory environment. And we don't hear the state to be arguing that she lacks standing to pursue relief for that claim. So I'll just briefly touch on standing for the other two claims. The first one is for parental rights. Mirabelli v. Bonta, Mirabelli v. Bonta just addressed this issue, held parents have standing when they are the object of the regulation at issue. Here what we have is policies preventing parents from getting notice and having an opportunity to opt their children out of an issue or a situation that implicates our health and safety. For standing, of course, the merits of the claim have to be assumed in the plaintiff's favor. So the court doesn't need to decide whether or not the legal theory is correct to conclude that they're standing, because if you assume the parents are correct, they're the objects of the regulation and they have standing under Mirabelli. Then if you turn to the Title IX athletics claim, there are funding conditions that apply to all of the defendants here. And there are three different ways you can find standing for the Title IX athletics claims. First, past events are predictive of future events. Last year, in the very first wrestling tournament of the season, KM was matched against a biological male. We know that there have been 2 males on the team. Neither of them has graduated. There's no reason to believe they won't be wrestling. It's easy to predict that the same or a similar thing would happen again. Secondly, regardless of that, withdrawing from sports, as KM has done at her mother's direction, is a reasonable response to the risk of having to be put in this position again. And just withdrawing from sports is itself an injury. That's supported by Friends of the Earth v. Laidlaw, for example. Then there's a third rationale that Your Honor could look to. The Supreme Court explained last term in Bost v. Illinois State Board of Elections that being subject to improper rules of the game is itself an injury, and anyone participating under rules that are unlawful has standing to challenge those rules, regardless of whether or not they will necessarily in the future be subject to an additional injury as a result of those rules. So here, KM has to participate under policies that she contends are unlawful and violate Title IX. Again, for standing, the court assumes that the plaintiff's legal theory is correct, and so having to participate under policies that violate Title IX is itself an injury under Bost. After standing, I think Your Honor.
Yeah, let's just talk about standing first. So I
Certainly.
appreciate that, and then I'm going to hand it over to the other side. But I'm going to be honest, they didn't dedicate, I don't know who's going to argue, they didn't dedicate very much to the standing arguments in their briefing. So I'm curious to see if they really go hard on that issue or not, because again, there wasn't much briefing provided. So, but let's hear. All right, thank you.
Your Honor, this is Spencer Coase on behalf of state defendants.
And you want to bring that closer to you just so that,
Sure.
bring it down.
Is
Thank
this
you.
better?
Yep.
Yeah, Your Honor. So there's probably one point of agreement that we have with plaintiffs here is that the state did not raise a standing issue with respect to the hostile environment claim. The state isn't really implicated in that part of the claim, so that was not the focus of our standing argument. And the other preliminary clarification I want to make is that standing is a threshold issue, but in a mandatory injunction context, so is the demonstration of irreparable harm. There is some overlap here, but the standing, the showing that plaintiffs need to make for a mandatory injunction like the one they're asking for is much higher in these types of cases. So standing might require a lower showing of damage or injury, but in the mandatory injunction context, the Ninth Circuit requires a showing of extreme or very serious damage that will result if the plaintiffs are denied injunctive
Right,
relief.
and I understand that. That's obviously a separate issue, though,
Correct.
so I want to focus on the standing part first.
Correct. I just wanted to address that. We also view that as a threshold issue, but focusing first on standing.
Well, it's a challenge or an obstacle potentially, but as far as threshold, that they're in the door and they're able to argue
Correct.
these arguments, standing is what I want to know about.
Fair enough. So, Your Honor, we give the cases in our brief of Clapper, Lujan, and Lyons that requires any plaintiffs seeking Article III injunctive relief to show standing by demonstrating injury that is actual or imminent, not conjectural, and certainly impending. The entire reason that we are here in the courtroom today on August 18th, 2026, because plaintiffs want a determination within a week because KMK is going to play soccer next week. There is nothing in the record indicating there is any transgender soccer player in the state of Washington, in the Puyallup School District, or at her school. So there is nothing about that threatened action within a week that is certainly impending. What they're going for there is purely speculative. As for wrestling, now, plaintiff's counsel mentioned in a presentation that past is predictive of future, that they have identified 2 transgender wrestlers at the Emerald Ridge High School wrestling team that played last year. But the assumption that the record shows that they're going to play this year just doesn't exist in the record.
You rely on the Females Athletics United case quite a bit in your arguments. That Eighth Circuit decision identified standing, and they pointed out, hey, there was a high likelihood that they would face this pitcher on a girls' softball team in the very near future.
Correct.
They make these allegations in their complaint talking about, hey, look, I wrestle at the 190 weight class. There's these 2 other transgender females that are at Emerald Ridge. One, I wrestled at the 190 weight class. The other is at the next higher level weight class. And there's a high likelihood that I will face one or the other, because either I make weight at 190 and I will wrestle the person or I'll be matched up against the person that I previously wrestled, or I will not make weight and I'll be in the higher class and then face the other individual, which seems to sound like FAU, quite frankly. So why is it different in this case?
So FAU is an interesting case because there were actual multiple plaintiffs that claimed standing in that case.
Only one individual was found to have standing.
Only
It was
one
athletic
individual,
one,
correct.
or
Only
athlete one.
Right, the first plaintiff in that case was found to have standing because that plaintiff played on a team that was already matched up to play against, in that case, was a transgender girl softball pitcher.
Correct.
So they were playing already in the regular season. The rest of the plaintiffs were in the same league, but they were only potentially going to be matched up against that team in the playoffs or postseason. So it wasn't reasonably certain that they were going to play each other. And in that
it's
case,
pretty reasonable concern that there's going to be some additional wrestling matches between Rogers High School and Emerald Ridge. They're in the same district. I think there might be the same size of schools, if I'm not mistaken. So my understanding is they quite often play each other in different sports, which would include wrestling.
that might be, Your Honor, but we don't have nothing in the record to indicate these 2 identified transgender wrestlers are even still on the team or even want to wrestle anymore. The last thing we have on the record for the first identified wrestler is that she dropped out of the state tournament, and the second one is not even in her weight class. So there's not the reasonable certainty that KMK will
Right,
play
but I'm just
either of those
focused
2.
on the allegations right now, I'm not focused on the underlying record that supports or doesn't support potentially the actual request for the injunction. I'm just looking at standing. Does the complaint itself allege potential facts that would provide that, hey, there's an opportunity or chance or plausibility that they will face each other at some point in the future?
I think we would submit, Your Honor, that it doesn't meet the threshold of standing because it doesn't show that's a hypothetical. It's not showing that it's a certainly impending, and that's just the basic threshold that they need to meet for standing, and it doesn't cross that, and it would not cross the certainty required for irreparable harm. That is our position there.
All right. As you might get the sense, I don't know if that's a winning argument on your part. So anything further on standing?
A couple of these things that they brought up. I think the only thing I would say for standing, Your Honor, is that just because plaintiffs make a showing on standing does not mean that they meet their burden to demonstrate irreparable harm that is consistent with the mandatory injunction
That's a
framework.
different issue. Just wanted to focus on standing right now.
Correct.
Okay. Anything else on standing?
No, Your Honor.
All right. Thank you very much. All right. So let's move on then to kind of the next issue or issues. I mentioned the Pennhurst notice requirement. I think that kind of bleeds into these issues of potential deliberate indifference and whether or not this is a known injury for which there's now potentially a violation. So I don't know if we need to do that separately versus just kind of weaving it into your arguments if you want to discuss it as you go along. But there are 2 claimants in a sense. One is the parent, and talking about substantive due process rights of the parent. And then, of course, there's the Title IX allegations regarding whether or not the current policy violates those Title IX or not. So let's first focus on the parent and not talk specifically about Title IX, although it might bleed in a little bit, and then move over to Title IX afterwards. But I want to hear argument about the parent's substantive due process rights first.
Thank you, Your Honor. So these two claims, as Your Honor has picked up on, are related in that they would both lead to similar but not identical relief, and in other senses as well. But I'll focus on the parental rights claim. Though the fundamental parental right includes making decisions about the health and welfare of your child. That includes making safety decisions, like the decision about whether to participate in a contact sport like wrestling against males. BPJ from the Supreme Court just a couple of months ago emphasized that there is inherent risk to girls participating, especially in contact sports, when they have to participate against males. And
I think your experts say the inherent risk is there regardless of whether or not the transgender girls are participating or not. I think they identified studies where there's an increase in concussions for girls who play soccer and basketball, and even when you compare them when boys play football, if I'm not mistaken, that it's just inherent for whatever reason that they get injured more in general. So you are indicating that there's this heightened risk potentially of injury if you include transgender girls. But how do you quantify that? Because again, your studies that your expert points to, Carlson, if I'm not mistaken, talks about specific studies that show girls in girls soccer and in basketball have a higher rate of concussion than boys playing boys soccer and or even football. So how do you quantify that even additional risk somehow
So, Your
that
Honor-
you want to say is there because of the inclusion of, I don't know how many, 1, 2, 3, a full team of transgender females? How do you quantify that?
so, Your Honor, Dr. Carlson's report certainly points out that girls are more prone to these injuries based on the literature, and discusses how when you compare mass and velocity, now when they're a male and a female in the same weight
That's not
class.
the studies he quotes, though. He says, as it stands, when females compete against each other, they already have higher rates of concussive injury than males across most sports. That's docket 36-4 at page 51. So it's not just
Oh,
that.
sure. Okay, I'm sorry, I misunderstood your question, Your Honor. Yes, that's true, that's what the literature has shown. But the risk is even greater if they are facing an athlete who
Why, though?
because males have inherently greater strength capabilities, greater aerobic capacity, they're going to be
How do you
moving
quantify
faster.
that additional risk? Is it a 1% chance of higher risk, a 50% chance of higher risk, a 90% chance? How do you quantify that? Because he doesn't quantify that.
Well, if our expert hasn't quantified it, I wouldn't hazard to put a number on it, but Your Honor doesn't need to put a number on it to recognize that there is an incrementally greater risk.
Well, you're asking to make a finding that there's going to be irreparable harm if there is a transgender female participating because of this heightened risk and that it's inevitable. But you are saying you can't quantify it, at least your expert hasn't quantified it. So how do I know there is this inevitable injury that's going to happen at some point?
So Your Honor does not, to be clear, Your Honor does not have to make that finding to rule on a preliminary injunction, particularly when we're talking about the notice and opt-out right that parents have. It's parents who get to decide whether to take on that incrementally greater risk for their children. And what we're asking for here is not an overall change in policy. We're not asking for a preliminary injunction that would prevent any athlete from participating in sports. What we're asking is for the district and other officials to facilitate KM not being matched against those athletes. So Mahmoud, the Supreme Court's decision 2 terms ago, explained that parents need to be provided an opt-out. That abrogated Ninth Circuit precedent that had said parents don't have fundamental rights once you cross the threshold of a public school, and it abrogated earlier decisions that had said parents don't get to make decisions about what their child does and doesn't participate in when they're at school. So, and then the Supreme Court extended that and emphasized that parents are likely to succeed on that claim under their fundamental parental rights under the Due Process Clause, not just when it's a First Amendment free exercise claim, as the claims were in Mahmoud.
So let's say you are right that substantive due process rights are that I get to direct my child's childcare, mental health issues, potentially physical health issues, I have the right to have information about that and direct it and, appropriately approve of certain things and be informed of them before, the school does something. But you run into a wall potentially when you start saying, I have that right, but then I also have the right to know about other individuals' privacy and their mental health and potentially their physical issues when you start asking about being informed about facing a potential transgender athlete. And I'm not sure of any case law that says, hey, I get to know about other individuals' potential privacy issues. And I get to also direct the school to make sure they tell us all of these things. So what case law can you point to that says, in addition to the known ones that you've identified, I get to then do more? Where is that case law at?
So, Your Honor, let me just clarify. The defendants certainly have framed this issue as the plaintiffs are wanting to know private information about other students. We are not asking for that. We do not need to know.
It's by definition, you're being informed because you're being told, hey, you're potentially matched up against a transgender athlete. And that's somebody's privacy issues there.
So we're talking about a constitutional right here. And the defendants have, especially the district, when they're seeding these matches, they have the opportunity to just not match KM against a transgender athlete, and then they won't have to provide any information whatsoever. There are a lot of different options that they could use
The
to
record
make this happen.
indicates they don't always know. If
So-
I'm not mistaken, I think there's a couple declarations either from the superintendents, I forget the name, the person who submitted the declaration, that they actually don't have that information all the time. Sometimes they do, but maybe not all the time. So how does that happen if they don't even know?
So, assuming arguendo that there are circumstances where the district doesn't know, we wouldn't try to hold them in contempt for not providing notice of something that they truly didn't know about and weren't even able to access. But the district does have this information. They keep the student's legal sex in the student's official records. They have every student do a physical before they participate in sports, and the forms that doctors fill out include their biological sex, regardless of us having a separate gender identity.
Does
So
it?
this is information that the school district
I
can
was about to
easily
say,
get.
does it? Do you have a sample of what one of these forms looks like? Because it's not in the record right now, and I don't know if that's true or not.
Do we have that printed out? I'd be happy to provide it to Your Honor.
I'm
It's
just saying
available online and all.
Not before me right now, so I don't know.
I understand. Absolutely. So they already have access to this information. And so maybe there's a mistake and something slips through the cracks. We're not going to try to, penalize the district for failing to provide us information on that. But what they have to do is not withhold the information that they do have. And here, we know that there are 2 transgender athletes on the Emerald Ridge team. Part of the problem is that Ms. Brown is not getting notice. And so she can't be assured that there aren't others on soccer teams where KM would be playing against them. That's why KM is not playing soccer this fall. She hasn't signed up to play soccer at school because of this risk that she would have to be playing against a male. And if they want to just provide us notice that there are no transgender athletes involved in the soccer program, then that would help, and she'd be able to act accordingly. But as of right now, Kim has reasonably withdrawn from all of these athletic opportunities because she just doesn't have the information. The district has it, and they won't share it with parents. So we would ask the court to require defendants to provide Ms. Brown with notice or simply avoid matching KM against male athletes, as happened last year. And that would be all that's necessary for preliminary injunctive relief on the parental rights issue in this case. Again, Your Honor, we're not asking for a universal injunction or them changing their policies. We're just asking for the notice and opt-out right that Mahmoud and Mirabelli just recognized from the Supreme Court.
Okay. All right, thank you very much. Let's hear from the defense on this issue.
Your Honor, just to clarify, I can speak for state defendants on certain things, but as for what records the district or WIAA may have, I believe those questions might be better directed to counsel for them, but I'm happy to speak first on the existence of the right of the substantive due process right they claim exists. I don't know if Your Honor wants to hear about that first, or if you want to hear more about the question from counsel for WIAA or the school district for what records they may have.
No, I want to focus on the substantive due process rights.
Okay. So, Your Honor, their entire 1983 claim for this claim is based on the unenumerated substantive due process right, also known as the Meyer-Pierce right, the parental upbringing right, that exists under the 14th Amendment. It is not connected with the religious upbringing right that was at issue at Yoder and Mahmoud. Parents for Privacy v. Barr, the Ninth Circuit decision, makes clear that these are separate rights, and the religious upbringing precedent has no import on the 14th Amendment. They try to bring in Mahmoud more in this oral argument and on the reply, more so than they did in their initial motion, but it just doesn't apply. Mirabelli did address Mahmoud, but because there were two classes of parents in Mirabelli. One was bringing a religious upbringing claim, and the other was bringing the 14th Amendment substantive due process claim. And there's a long line of history that cautions against overreading the second, the unenumerated one, including Mirabelli itself in Justice Barrett's concurrence. But we also give the examples in our...
Mirabelli does, though, give parents the right to have information that potentially affects their child's mental health. Would you agree with that or not?
Mirabelli did say that a parent's right to raise her child includes the right to participate in significant decisions about her child's mental health, including the right not to be shut out. And so what was at issue in Mirabelli was a California policy that prevented school officials from disclosing information about a student's mental health, there they said gender dysphoria, to their own parents.
So is it a far stretch to say if I have the right to know about my child's mental health, I would also have the right to know about or decisions that affect my child's physical health? I mean, is that a far stretch?
That would be a question for a Supreme Court, but I'm certainly, they could try to make that argument.
I think Justice Barrett said, hey, this is something that's based on the nation's history and tradition, and that parents' ability to know about their children's upbringing is found within the nation's history and tradition.
They certainly found that right to exist, the nation's history and tradition, but what was not found was...
I think Justice Kagan, even in her dissent, mentioned to the effect that, hey, I think there probably are some parental rights that are guaranteed by substantive due process, although she took issue with some other issues, but I think she mentioned that. I'm looking for my notes because I'm trying to find my notes on that, where I can quote exactly what, well, anyway, go ahead.
Your Honor, I'm not arguing parents don't have a substantive due process right to control the upbringing of their child under the 14th Amendment. There has been recognition of that right dating back a century. But what's also been recognized is that that right is not boundless, and that any kind of substantive due process right, especially if it's not if it's unenumerated, needs to be defined narrowly. And that's what Justice Barrett's really cautioned against in her concurrence, to read this too broadly. She said there's a demanding test for recognizing unexpressed rights, that they must be deeply rooted in the nation's history and tradition. But there is no history or tradition of recognizing parents' rights to force schools to go out and learn the transgender status of other people's kids. That just doesn't exist. Now, the definition of this right has changed a few times. In their motion, they said parents have the right to direct the conditions under which their child interacts with others, even at schools. This is made-up language that doesn't appear in any case. And it goes against a long history of precedent, both from the Supreme Court and the Ninth Circuit, that recognizes that parents' rights to control their children's upbringing faces limits when you're talking about the school setting. We point to, going back to Jacobson and the vaccine mandates, the Fields case talking about parents' rights to control curriculum, but even Parents for Privacy v. Barr, the Ninth Circuit decision, said that parents don't have the right to tell kids who to let into their bathrooms, and letting schools decide to let kids go to the bathroom consistent with their gender identity. Parents do not have that right. In fact, the Ninth Circuit specifically said that parents do not have a right to direct school administration more generally. It specifically endorsed a view that parents don't have the right to tell how a public school teaches, including how they administer their extracurricular activity like athletics. And another thing we do point to in our brief, Your Honor, is that a common theme throughout all these parental upbringing cases is the severity of the damage to the parental-child relationship. In the Ninth Circuit, it has to work essentially as a severance of the relationship. It has to really impinge that damage between a parent and a child. And so we give the example of the Henry A. and Benitez cases. There's no such allegation here. And I think the last point I'll make on this is no court has ever endorsed an understanding of fundamental rights, that anybody has a fundamental right to infringe somebody else's fundamental right. Your constitutional rights end where somebody else's begins. And so, however they couch it, if plaintiffs are coming up and saying, we have a right to tell a school to go violate the constitutional privacy rights of transgender students and their parents, or their statutory privacy protections under FERPA or HIPAA, they don't have that right. And there is no history or tradition of any court recognizing the parent's ability to do that. I know Your Honor has specific questions about what kind of records the school has. I believe those are better addressed to counsel for other defendants, unless Your Honor has additional questions.
Let me just ask briefly that question. I don't know who's, yes, okay, perfect. Ms. Al-Rikabi, did I pronounce that? I want to make sure I'm pronouncing it correctly. Okay, perfect. So happy to have you answer that question about what records, at least the record has. Yes, please, at the dais. And then I'll hear back from Ms. Thompson on, any brief rebuttal on this particular argument.
As far as the records that are maintained by the WIAA or the district that students are required to provide to their doctor, which plaintiffs mention in the supplemental declaration of Dr. Carlson, the PPE forms that are mentioned, which are not provided in the record but can be supplemented. Those are something that even on the WIAA website say, these are for your doctor. The doctor does not share those with anybody else. It just simply gives you are cleared to practice, you're cleared to participate in a sport. At the end of the day, the sport you're participating in is a privilege to participate in. That doesn't allow you the ability to infringe or pierce the federal privacy rights of another student, while plaintiff points to the fact that you can simply give notice of who you're participating with. That notice would require...
I understand that argument from Mr. Coates. I was just curious about what documents the district and or the WIAA or possibly even the superintendent's office might have on individual students.
Yeah.
Anything else?
No, nothing further than just you're cleared to practice.
Okay, all right, thank you very much.
Thank you.
All right, Ms. Thompson, briefly, because obviously we have other issues to talk about, but briefly, any response to any of the comments made?
Thank you, Your Honor. Just a couple things. The WIA form that we were talking about is linked in Dr. Carlson's expert report at footnote 17. So if that's something Your Honor would like to see, it's accessible there, but we'd also be happy to submit it as an exhibit. On the issue of whether or not school districts know about athletes, the possibility that maybe sometimes they won't know does not absolve them of providing the information that they do know. They knew here. Emerald Ridge knew that it had 2 transgender athletes on its team. They could have provided that information. It was no secret, but they refused to do so then, and they're continuing to refuse to do so now. That's the problem here. So if they have information within their control, which they do because they've already collected this information, and even if you set aside the physician's clearance forms, they've got it in the legal records of the students' transcripts. So they can provide, or they can use that information however they want to respect.
Can they use that information, though? It's private. It's not information to simply just tell people about, hey, I have a student who is transgender. That's where it goes back to the original question to you, which is you're kind of running up against somebody else's rights potentially there.
So we certainly disagree with that, Your Honor, because there are a lot of different options that schools could use to provide this information without interfering with anyone's privacy interests. They could set the matches ahead of time in such a way that KM doesn't have to wrestle against a transgender athlete. They can provide general notice that there is going to be a transgender athlete. Now, we think it needs to be match by match so that KM isn't excluded from an entire tournament, but at the very least, they could do that, and they're refusing to even do that. The school districts could also, I mean, it doesn't need to be announced over the loudspeaker. Ms. Brown is happy to keep information confidential if she has it.
In
They can
days of
provide it.
social media, nothing is confidential once you disclose it to somebody. It's not.
Your Honor, the Supreme Court recognized the possibility of confidentiality agreements just recently in the Povey Labrador case. We can't just discount that people will abide by their agreements. But in any event, there are plenty of ways to avoid the situation even arising to begin with without having to completely exclude KM from all participation in school athletics. That the solution that the defendants are offering, just don't participate in sports, that would be like telling the parents in Mahmoud or the parents in Mirabelli, well, you don't have to send your kids to public school if you don't like our policies.
The problem is, at this stage, you're asking for a preliminary injunction, and in order for you to get the preliminary injunction, I have to find on that there is a likelihood that you're going to be successful, that there is this enumerated right that you say exists. And, I know you can say, hey, we can work out some kind of deal, but it still is premised on that I make a finding that that right actually exists. And so that's where I still have the question of what enumerated right is there that officially allows a parent to get that additional information about other students, and I think, as Mr. Coates says, to, in essence, tell the school how to run these, or the district or the state, how to run these athletic programs.
Your Honor, parents have a fundamental right to make consequential decisions about their children's health and safety. Mental health was at issue in Mirabelli. Physical health is at issue in other cases like this one. It's been recognized since the 1970s in JR v. Parham. This is not in question, and it also does not turn on.
That's not the debate in my mind. I'm not, I think you're probably right. They have information there that, or the right to know about their child's health and well-being, et cetera. But it's running up against another constitutional right of privacy. And, again, how does that right then allow you to get information about other individuals?
So I think I've already said
I know,
we're not
going-
demanding that information, but I understand Your Honor's question. Insofar as there's no possible way to provide this without providing private information, maybe that's protected by FERPA, then now we think there are plenty of ways to do that. But if that were the only possible way to do it, then they could provide Ms. Brown with notice, before a certain tournament where there are dozens of athletes, that she probably needs to opt her daughter out of participating in that tournament. But that wouldn't require any personal information to be revealed, but it would protect her right to make the consequential decision for her daughter as to whether it's going to be safe and in her daughter's best interest to participate against male athletes. The Supreme Court emphasized this in BPJ just last term. That
I think Mr. Coates does point out, and I don't have it memorized, but there is case law that says to the effect, courts should be treading lightly before identifying unenumerated rights or unenumerated substantive due process rights. And that's why I feel, hey, I need to tread lightly here. I'm a little bit nervous about, saying, hey, there is this right to arguably infringe on somebody else's privacy.
So, Your Honor, again, it is not our position that there is a fundamental parental right to infringe on somebody else's privacy. There is a fundamental parental right that includes making consequential decisions for your child's well-being. And you don't waive that right when you enroll them in public school, and you don't waive that right when you give consent for a girl to participate in what is called girls wrestling or girls sports. So they need to provide information that will allow parents to make that decision. We think there are plenty of ways they can do that without infringing on privacy rights. But the Supreme Court just said in Mirabelli v. Bonta that all of this prior Ninth Circuit precedent about you don't have any parental rights once you cross the threshold of the public school, or there's no fundamental parental right unless you've shown, a rupture of the parent-child relationship, that's all been abrogated. So there shouldn't be any reliance on that Ninth Circuit precedent that is no longer good law under Mirabelli. The Supreme Court, that was a preliminary injunction case, and the Supreme Court said the parents who are raising the due process right are likely to succeed on the merits in showing that the school cannot cut them out of making important decisions for their child's mental health. Here it's physical health. And the Supreme Court had just said in Mahmoud, which was the precedent that was expanded upon in Mirabelli, it had also said that schools do not get to stigmatize and ostracize one group of students in the interest of stigmatizing and ostracizing another. That's what's been happening here. KM is completely excluded from all sports because of a possibility that maybe the district wouldn't figure out a way to let her opt out of wrestling transgender athletes without infringing on somebody else's privacy. They've got to do a little bit to try to protect fundamental parental rights and let parents be the decision makers.
All right, thank you very much.
Caitlin, what for the district? Can I be heard for that on this issue?
Yeah, no, I think we're good. No offense, but I think we're good. I know what the arguments are. I understand each party's position, and again, it's kind of crossover. No offense. I don't expect you to really give me more than already what's been provided, so I appreciate the offer, though. Let's move into the Title IX issues, and let's hear about Title IX. Actually, no. Who's doing Title IX?
Would you like to start with the athletics issue since we're talking about that, or the harassment?
Doesn't matter to me, one or the other.
Yeah. Sorry, Your Honor, I suppose it makes sense to continue with athletics since that's been the focus. So the Title IX athletics issue is related to this in that our claim is that KMK is entitled by Title IX to not be excluded from sports and denied educational benefits on the basis of sex. And that is what a policy like this does. Title IX guarantees that no person shall be excluded, denied the benefits, or subjected to discrimination in education programs. And the Supreme Court just held in BPJ a question that had been litigated back and forth in courts across the country. It just held that sex in Title IX unambiguously means biological sex, not gender identity. So Title IX does not provide a separate protection for gender identity, and using that as a substitute for sex is not consistent. As we've already discussed, when males compete in girls' sports, girls are denied the benefit of school athletics. BPJ acknowledged this greater risk of injury, loss of competitive opportunity, and that's the whole reason for allowing separate teams on the basis of sex. The separate teams on the basis of sex comes directly from the regulation, which is an authoritative interpretation of Title IX's non-discrimination rule in 1681A. The regulations at 10641 say, they repeat the non-discrimination rule in subsection A, and then they go on to say, notwithstanding the non-discrimination rule, there may be separate teams for the members of each sex. That means male and female. It doesn't mean separate teams based on gender identity or any other consideration. And whether a school chooses to comply with A by having a sort of co-ed or sex-neutral program, or B, separate teams for males and females, they've always got to provide equal athletic opportunity for girls. That was the whole point of Title IX applying to athletics at all. Creating the opportunity and allowing girls to get the benefits of school sports. And that's exactly what happened here in Washington. Schools nigh universally created separate boys and girls teams, and when girls became more and more interested in wrestling, WIAA pushed for a separate girls' sport for wrestling. They didn't do that to protect boys from having to compete against female wrestlers. They did it to provide the opportunity for girls. So eliminating that is a violation of Title IX. And that would mean that KM has a right not to have to participate in wrestling or other sports against males, no opt-out required. That's really the only difference between the relief that we're seeking under the parental rights claim and the Title IX claim.
So Title IX has, and I'm talking about the actual statute, not the regulations that were implemented, within 2 or 3 years after the statute, at the direction of Congress. It says, and it specifically says, on the basis of sex. It says you should not make any decisions or discriminate on the basis of sex. That's the phrase. Your complaint acknowledges that these are not related, these decisions are not related to sex. Specifically, it says, by allowing participation on teams by members of either sex on grounds unrelated to sex, these policies undo the reasons for sex-based teams in the first place. That's paragraph 239 of your complaint. So you seem to acknowledge that these decisions are being made unrelated to sex. And if the decisions are being made unrelated to sex, then they're not, by the plain language of Title IX, 1681A, not being made on the basis of sex if they're unrelated to sex.
So to some degree, they ignore sex, but they're still
That's-
operating within.
I'm going off of your language, by the way. I'm not making this up. This
Certainly.
is your language.
And the teams are already separated by sex. Deciding to have a separate boys and a girls sports team is an inherently sex-based decision.
But I'm talking about the specific language of 1681A that says decisions basically on the basis of sex. You acknowledge in your complaint these decisions are unrelated to sex. So by definition, they're not in violation of the actual language. Forget about the regulations. I'm talking about the language of the statute. They're not in violation of the actual language of the statute.
So, Your Honor, the Fourth Circuit's opinion in Mercer is instructive on this point. They talk about how subsection A of the regulation basically transplants
Again,
1681.
the regulations, I understand Congress said, go make some regulations. But the regulations are still just regulations. The
Yes,
statute says, on the basis of sex, your complaint says, these decisions are unrelated to sex.
so that's certainly not what we're intending to allege, but we can always amend our complaint if
I understand.
that
but
helps, Your Honor.
For the present motion, that's what's in
So-
front of me.
I understand, Your Honor. Subsection A of the regulations just transplants 1681A, the core rule of Title IX, into the athletics context and makes clear that it applies to athletics. So if all we had was the statute, Mercer explained you would not be able to have separate boys and girls teams. It would just, you're excluding people from the boys team on the basis of sex or the girls team on the basis of sex. That would be unlawful. That's why the reasonable regulations that Congress called for account for biological differences and go on to say, even though it would be a violation of the same text as in 1681A, you may have separate teams separated by sex, and that's not what we have here.
So if we don't have teams that fall, I think as your words, the safe harbor of 10641B, if we don't have teams that fall within that, then by definition, they fall into the other category of 10641A and 10641C, that they must provide equal opportunity. I forget the exact language. So we're out of B, we're dropped into A and C then, and so the question is not about separate teams per se, it's does it provide equal opportunity at that point?
So if Your Honor is just talking about 1681A, the text of Title IX still,
Nope, I was talking
There's
about
no-
106.41, and you have the
Okay.
3 sections, A, B, and C. You're saying B has this safe harbor provision that if you separate by sex, girls or boys, then you must comply with that being quote-unquote biological sex. But if it doesn't comply with B, then you fall out of B, and now you're just left with A and C, and the question
Correct.
is there equal opportunity being provided?
right. And if you were to ignore the equal opportunity requirement and just do what's called for in subsection A, it would just be, okay, all sports are now open to girls as well as boys. But it's been recognized.
It doesn't quite say that that's exactly how you have to do it, though.
It's hard to see how you would be not discriminating on the basis of sex if you separated teams only on that basis. But of course, that's the reason we have all three subsections. That we agree that subsection C, the equal opportunity mandate, is a central requirement here. And it would be very hard to provide equal opportunity if you just opened up all the sports to girls too, because few girls would be making the team in a lot of sports. That's what's recognized in the 1975 regulations and the letter that the agency sent out to all the schools. So for equal opportunity, yeah, you could, maybe you could provide equal opportunity while providing co-ed teams, and schools often do in certain sports. You can have a co-ed riflery team or sailing or various sports where there isn't an athletic difference that's relevant to that sport. But when there is an athletic difference and physical differences that are relevant, to provide equal opportunity, you really need to provide girls with female-only sports. That's why that's been not universal for the last 50 years. What we have here is then taking the female sports teams and adding males to them, which means that they're not a separate team for females, and they're not providing equal opportunity for girls. At the very least, defendants adopted these policies knowing that they would be harming girls in a way that they weren't harming boys, and that's deliberate indifference. Deliberate indifference is a way of showing intentional discrimination.
And for purposes of this, when you say knowing they would harm, what is the harm? Is it just competitiveness, or is it something more than that? I just want to make sure we're clear about what it is you're saying is the harm.
So there's the increased risk of injury that we've already talked about, and there's the competitive harm, the inability to have a level playing field when girls are put up against males.
All right, and those are the only two harms. I want to make sure. Is there other harms, or those are the harms that you?
Those are the harms discussed in BPJ and that we're relying on for purposes of this preliminary injunction.
Okay, I just want to make sure, because I apologize, but so you're relying on heightened injury, potentially, and
The risk, yes.
level playing field or competitiveness.
Yes.
Okay. Got it. Sorry, I interrupted you.
No, absolutely. So we've already talked about how this is inconsistent with the regulations because they don't have separate teams on the basis of sex. One thing I just add to close is that there's a framework for talking about how intentional discrimination can be shown from the circumstances. There's a known impact on girls that doesn't exist for boys. These are regulations that already recognize that. Appendix 2 of the WIAA handbook requires looking at those biological differences. So girls can try out for a boys team if there's no girls team, but boys generally can't try out for a girls team. There would be no reason to have that asymmetry if you didn't take into account the biological differences.
So let me break it down a little bit more on these known risks. So one is this known risk of heightened injury or risk of injury. And that's where it comes back to my earlier questions about, hey, your experts don't quantify what that heightened injury is because they point to studies that say, I'm going to use the word inherently, and I don't know if this is true or not, but inherently, there's more concussions identified in girls' soccer and basketball compared to boys' soccer and even football. And so there already is a heightened risk of injury apparently associated with girls' teams. How do you quantify that additional risk that is somehow associated with the inclusion of transgender females?
So two responses. My colleague reminded me that Dr. Carlson does discuss findings of increased injury against males that were the basis for World Rugby's decision to use biological sex for dividing up teams. They were one of the earlier athletic associations to act on this issue and to, even before the internet.
And just so I understand, because I don't know much about rugby, is it a recognized sport within the WIAA and the school districts?
I do not know off the top of my head whether it is a WIA sport. Point is, there are studies in that context.
Is WIA, no?
No.
Okay, so rugby is out of the question at this point in
So
time.
it shows, yes, of course, and our client is not trying to participate in school rugby, obviously, since it isn't a WIAA sport. But it's relevant because it is scientific studies that show girls playing against girls is one level of risk, and girls participating and playing against males is even higher. So even setting that aside, though, the Supreme Court just explained this in a lot of detail. Your Honor wouldn't be going out on a limb to recognize, with the record that the Supreme Court just had, that males participating against girls put girls at a heightened risk of injury and deprive them of.
I read that, and obviously those are some clear statements that are made, but there's like no citation to any record when those statements are made. And so I'm curious where that actually comes from, because later on in that decision, PJ, there's a pretty big discussion about, hey, when you're dealing with medical uncertainties and scientific uncertainties, you really should leave it to the legislature to make those decisions, and the judiciary should not be making broad proclamations about what is accurate and what is not. And so it's just odd to me that there are some broad proclamations made right there and then later on say, well, you shouldn't really do this, though, because it's a lot of medical uncertainty that you should leave to the legislatures who study these policies and make decisions in the end.
So they explained that because it was a state law that was being challenged in BPJ. So they didn't have occasion to go beyond addressing the difference between a state law. But more importantly, some of these same experts had reports in the record in BPJ and additional experts.
Right, and so when those statements were made, none of those reports were actually cited to, and so I'm curious, where does that come from?
Well, the Supreme Court doesn't usually provide a lot of citations to the record. It
Well,
would be helpful if they did.
I know, exactly. That's why when I was studying, I'm like, I don't know what this actually comes from.
Certainly.
so.
If it would be helpful to Your Honor, we could provide cross citations to what we're saying to the evidence that was in the record before the Supreme Court.
Well, I have to imagine it's some of the same evidence that is now before us with these experts.
Correct.
Which, again, as I've mentioned, calling into question some of it because I'm trying to figure out what is that quantifiable heightened risk of including transgender females into a girls' soccer team, for example.
So one thing I would point out to Your Honor on that is that BPJ was a case focused on transgender athletes who were undergoing hormone interventions. And so a lot of the expert dispute in that case and in the reports that the defendants have provided to Your Honor is about, whether the male athletic advantage persists after an athlete has undergone cross-sex hormones or puberty blockers. Washington law doesn't ask them to participate after hormones.
Well, your own expert, though, says at present time there is very limited research on how puberty blockers affect physical fitness and none on sports performance. That's at page 126 of your expert report, Gregory Brown.
Yes.
So it sounds like there's really no studies on this.
Yeah, so we would presume that the inherent advantages persist, but the significance of this here is that, there's no indication that the
And
male
your
wrestlers
expert-
here have
your
even
expert doesn't-
undergone.
Your expert doesn't actually even come out and say, on a more probable than not basis, to a degree of medical certainty, all of this still exists, and therefore there's this heightened risk of injury or even performance degradation on behalf of girls playing. So they mentioned there's no studies, and that's presumably why they can't actually make those opinions.
Right, absolutely. It's only just very recently that really rigorous scientific studies have started looking into this issue. But more importantly for the question before Your Honor is that there's no evidence here and no indication that the male athletes that we know of in girls wrestling have even taken any hormone interventions. So our clients have got to assume that this
Why
is
do we
a
have to
teenage
assume?
boy because Washington does not require any of those medical interventions. WIAA says, you're not allowed to require them to have undergone medical treatment or provide
It's
medical.
difficult for me to make findings on assumptions.
I don't, so I think that the response would be the same if they were undergoing the hormone treatments, because the Supreme Court just recognized these risks in BPJ, even for athletes
I'm
who
looking at
were
your own expert
undergoing.
reports that are unclear at this point that you provided.
I understand, Your Honor. But I do want to emphasize that as far as we know, and again, it's the defendants who have the information. We don't have information about these athletes, and that's part of the problem. But they don't require someone, a transgender athlete, to have undergone hormone interventions. So we're not talking about a policy that is only limited to the type of athletes that were being, where the issue was in BPJ. It's worse here because it's not limited to someone who's had, a cross-sex hormone to decrease the amount of testosterone. It's not limited to an athlete who has undergone any of these things. It's just anyone is allowed to participate based on their gender identity.
Right, but for your claim is that there is this known risk of height injury potentially, or even competitiveness, loss of competitiveness. And for purposes of this stage of the litigation, I need to make a conclusion that there is a likelihood of success on that claim. And I'm pointing out to you right now, some of your experts are just unclear. And so how do I make that conclusion that there is a likelihood of success on the merits if what's being presented to me right now is not that clear?
So, Your Honor, as you well know, it's a likelihood of success. It's not final trial on the merits. And you're looking at some of the same experts that the Supreme Court agreed. You're not going to be going out on a limb and recognizing that there's an incremental increased risk of harm, either injury or athletic competition ability.
And that's where I've asked you quantify it for me. What is that increased risk? And I'm hearing you can't do that.
So the study that is in the record is based on a study of rugby competition, and they found a 20 to 30% increase in the concussions and ACL injuries.
Which is
there
a
have not been studies
definite
of
physical sport.
Absolutely, so is wrestling.
Well, they're not crashing into each other like they are in rugby, and
Certainly, all kinds of sports are different, but again, Your Honor does not have to make that final decision. BPJ recognized that there is an increased risk to girls, and Title IX protects sex. It doesn't protect gender identity, and it guarantees girls equal athletic opportunity. If you can have a policy where all males are allowed onto the girls' rugby team, then because there's no medical limitation on the Washington policies, that's essentially what we have here. Hypothetically, anyone who just says, I identify as female so I can play on the girls' wrestling team.
so
That's a violation of Title IX.
is it your position that anytime there is an inclusion of at least one female transgender athlete in any sport, that they will increase the level of potential risk of harm and substantively reduce the competitive levelness for all other females on that team?
Yes. That's what the Supreme Court decision agreed with. Sports are generally zero-sum. So if there's one male participating on the team, some girl is going to lose playing time. Some girl is going to lose a roster spot. Some girl is going to lose opportunities. And that's trying my best to quote Justice Kavanaugh's opinion. And yes, we absolutely agree with that.
How does that square with the Title IX regulations that talk about equal opportunity? And again, you're giving me kind of an absolute that if you just include one, that it's absolute, it's no longer equal opportunity. And again, there seems to be more factors when it comes to determining what equal opportunity is.
So there's a list of factors in subsection C that are things that the federal administrative agency will consider. Those have sort of given rise to these specific claims about effective accommodation.
And for purposes of Title IX, courts have said you can comply with the equal opportunity if you meet one of three type of tests. One is that showing substantial proportionality based on the number of women in intercollegiate athletic opportunity or proportionate to their enrollment. Two is proving the institution has a history and continuing practice of program expansion for the unrepresented sex. Or three, where the university cannot satisfy either one or two, that it nonetheless fully effectively accommodates the interests of women. So you can do one of the three, basically.
So that's a sub-regulatory test that is set out for complying with subsection CA. Subsection C1,
Right.
the
And since, as
effective
you said,
accommodation.
we're no
And
longer
we're
meeting-
not alleging that specific type of claim at all.
But since you say we are no longer part of the safe harbor of subsection B, then we have to start looking at subsection A and C together.
Certainly, you always have to comply with subsection C, but meeting the three-part test is not the only way to, or failing to meet the three-part test is not the only way to deprive girls of equal opportunity. The umbrella language that we're talking about here is equal athletic opportunity, specifically for girls, because that was the whole point of Title IX. So we are not trying to show a violation of the three-part test for effective accommodation, though when some of the roster spots are actually going to males, that would be a whole different issue. We're just saying that putting males into girls' sports deprives girls of equal opportunity.
And by the way,
In
I
a
think
general sense.
wrestling is a no-cut sport, I think is one of the declarations I saw.
Correct.
So in this case, KMK would still be able to participate?
Well, she had
No,
to
she-
wrestle a male in.
Right. No, I understand the
So
allegations,
yes, she
but-
wouldn't be cut from the team, but that's only one way that girls can lose opportunity. And our argument would be the same in a cut sport, trying out for the soccer team, trying out for the volleyball team. So in a sense, it's being applied to wrestling here, and that's all the preliminary relief we're looking for, wrestling and soccer. But our argument would be the same in a different sport. And that's why this Supreme Court's opinion in BPJ sets a roadmap for all that we're asking the court to do, recognizing that sports is generally zero-sum. So even if it's not losing a roster spot here, it's losing the actual competition, or as has actually happened here, because of the risk, she's had to withdraw from wrestling altogether.
All right, anything further on this issue, on these issues for the Title IX?
Thank you, Your Honor.
All right, hey, thank you very much. So, yes, I don't know who's going to,
I think that's me.
Mr. Coates again? Okay, thank you.
And, Your Honor, I'm happy to follow kind of the outline of issues that plaintiff's counsel followed, but I noticed that the spending clause argument was not discussed. Would you like me to address that?
Sure, and then I can give a little brief response if I need to from the other side.
Okay. Your Honor, I think it's the position of defendants that the spending clause bar under that was recognized under Roe v. Critchfield and Pennhurst, Medina, and Landor acts as a complete bar to Title IX liability with respect to the claims against the gender-inclusive policies. In order to get any Title IX injunctive relief against the state under the spending clause jurisprudence, plaintiffs must win that it was clear and unambiguous when the state received federal funds that Title IX barred girls from girls' sports. And they can't do that. There's not a single case that supports this reading. And as Your Honor just saw, the regulations are anything but clear. They do prohibit intentional discrimination on the basis of sex, but they don't say anything about gender identity. And so without that kind of intentional discrimination on the basis of sex, gender identity inclusive policies do not clearly violate Title IX, do not clearly violate the regulations, which is why no court has ever held that they do. In fact, even in BPJ, which is the case that they rely the most on, it was very clear from the very first footnote that that court was not answering the question of whether, quote, biological males who identify as females could participate on girls' or women's sports teams. And so if it wasn't clear in BPJ, 3 weeks after they filed their complaint, it could not be clear to Washington authorities at any point before that. There is not a single case that supports this. And yes, executive administrations have gone both ways, but that's not an indication of what Congress was thinking. And so when this issue has come up in courts, whether it's Female Athletes United, whether it's in the Castaneda decision in Oregon, whether it's in the Soule decision, or whether it's in the Tennessee versus Department of Education decision, all those courts said that states may have separate programs based on gender identity, not biological sex. And so the spending clause argument needs to be made from the perspective not of a judge who's looking at the regulations 50, 60 years after the fact and trying to resolve ambiguities, but from the perspective of a state official who is engaged in the process of deciding whether to accept federal funds. And there's not a single authority dating back decades that would indicate that Washington violates Title IX by having gender-inclusive policies. And to the extent that they argue that it's obvious, as Your Honor pointed out, and as they admit, a lot of the scientific studies they rely on come out only recently, and they are anything but conclusive. There's nothing established with any degree of scientific or medical certainty that cisgender girls will inevitably be injured should they play with or against a transgender girl, or that there's a massive deprivation of participation opportunities such that they would violate Title IX. None of that is clear. But in order to get any kind of injunctive relief here, Congress needed to speak with a clear voice that was prohibited. It didn't. And trying to retroactively read Title IX that way isn't allowed under the spending clause jurisprudence. So if Your Honor agrees with that, we don't even need to get to the statutory regulatory question, but just viewing that as the threshold argument and issue.
All right, thank you. The Second Circuit case, Soule, S-O-U-L-E, has a footnote in there. I think it's like footnote 2, if I'm not mistaken, that talks about its interpretation of what the Ninth Circuit has done with regard to waiver of notice for purposes of Pennhurst. What's your thoughts on that footnote? If you know what I'm talking about.
I think I do, Your Honor, and it was discussed a little bit in the massive magistrate judge decision from the Castaneda case.
110 pages.
It was very big.
Yes.
But I believe the argument you're saying is that it's an intentional act by a state to craft policies in a certain way, and so that will kind of waive any kind of clear notice complaints from the state against a spending clause kind of argument. Is that what you're generally referring to?
Right, that they had, at least as the argument is, that they had notice of this effect or impact on competitiveness or potential heightened injury, and therefore, at least as the argument goes, that there is this clear violation at that point, and therefore you don't need to have the notice under Pennhurst.
Right, and so I believe the magistrate judge in Oregon did a very good job of addressing that and countering that the intentionality here has to be the intention to choose a policy that intentionally discriminates against girls. The intention here is for a state to construct a policy that allows any student to participate in the sport consistent with their gender identity. So the intentionality really has to match up with an existing Title IX violation, which is not present anywhere in the record and is not present anywhere in the law.
Okay. All right, so let's move on to, and again, I'll allow Ms. Thompson to respond on the Pennhurst issues if need be afterwards.
Okay. Title IX claims, whether they be for sports or bathrooms or facilities like that, always require intentional discrimination on the basis of sex. Washington's gender-inclusive schools policies do not discriminate on the basis of sex. They are facially neutral and do not mention sex at all. Discrimination, we know, is intentional unequal treatment. These policies do not do that. They treat all students the same, and so do not discriminate on the basis of sex, just like the policies did in Parents for Privacy v. Barr. What plaintiffs are alleging are quintessential disparate impact claims. They try to couch a lot of the deliberate indifference arguments in terms of intentionality, but there was no evidence in the record or in the legislative history of these laws that Washington intended to discriminate against girls on the basis of sex. I don't think there's any real argument that disparate impact claims are not allowed under Title IX. Title IX is only directed at intentional discrimination against girls, or intentional discrimination on the basis of sex. The deliberate indifference argument runs into a few problems. One is, as we show through case sites to like Gebser and stuff like that, and in cases like that, deliberate indifference framework only applies in cases that do not involve an official policy of the recipient entity. They're just not intended to do that. They don't, and even the Soule opinion admitted that the deliberate indifference test doesn't apply where the alleged Title IX violation is a facially neutral policy. And that's exactly what's happening here. And I'll also direct the court to the Feeney decision. Now that's an equal protection case, but you can draw the line very easily to Title IX cases, where simple knowledge of an impact on one sex or the other is not going to be enough to show intentional discrimination. And that was a case where Massachusetts had a statute that created a preference for veterans' choice, which directly impacted women in that state because only about 1.8% of veterans were women in Massachusetts. But the Supreme Court said that that was not enough because intent as volition, as intent of consequences, is not enough to show intentional discrimination. So what needs to be shown is that a state selected or reaffirmed a particular course of action, at least in part because of, not merely in spite of, its adverse effects. And so applied here, plaintiffs would have to show that OSPI on down intentionally chose gender-exclusive policies because they wanted to discriminate against girls, not in spite of the impacts that might be felt in some sports, the actual severity and prevalence of which are still unclear. They can't show that, nor have they even tried it. And that failure of showing, that is fatal to their entire Title IX claim, just from the outset of the statute on down, without even getting to the regulations.
Their argument is something to the effect that allowing transgender girls to participate on girls' teams is an intentional decision to allow biological males onto separate girls' teams, and that is in and of itself a discriminatory intent.
I think there's a reason that argument has never carried the day, Your Honor, because that does not show any kind of intent to discriminate against girls. The intent here with these policies is to establish a non-discrimination framework on the basis of a gender identity for all students, boys and girls. There is no intentional discrimination against the basis of sex. There is no intent to say eliminate girls' sports, and that was not the intention of any of these policies. The intention was to have every student be able to choose the sport consistent with their gender identity. And that's just having that policy does not violate Title IX, which is why no court has ever found that it does. Unless Your Honor has any further questions with the statute. I'm happy to talk about the regulations and that kind of argument very briefly, unless if you have specific questions.
If you want to talk about it, but I think I want to give the other side a chance to respond. So. Okay.
The only other thing I'll mention, and just to caveat it, is that I know the hostile environment Title IX claim was not discussed. If that is of concern to Your Honor, I will have to direct the attention to my counsel with the co-counsel with the PL School District.
All right, we'll see what Ms. Thompson does if she raised that or not. So.
Absolutely. Thank you, Your Honor. I'll start with the clear notice issue. This is not a qualified immunity case. There doesn't need to be clearly established law putting Title IX recipients on notice. And in 1975, the agents explained that you can't just create co-ed teams if girls wouldn't qualify for those teams. That puts them on notice that what matters here is accounting for athletic advantage. States would not be surprised to find that putting males into the girls' programs deprives girls of equal athletic opportunity. And we don't need to have cases pointing to that. To the extent that some of this is new and newly being developed, that's because the phenomenon of males wanting to participate in girls' sports is novel. This is something that has just arisen in recent years. We wouldn't have expected the agency or states to have been asking that question in 1975. It would have been unfathomable that you would say you're going to have separate girls' sports teams. but actually males would be participating on them.
On that note, since it's a new issue that wasn't on their minds when they first drafted either the statute or the regulations, how can we say that those statutes and regulations clearly indicate that having transgender policies violate the statute if it wasn't even on their mind?
So the clear notice requirement doesn't require the statute to specify all of the factual circumstances. It just requires showing that, like, the basic conditions of no discrimination against women in this case. Jackson v. Birmingham School Board, for instance, is a case recognizing that, yes, there was clear notice for a new form of discrimination and a new context. There didn't need to be a whole bunch of case law explaining that. And in fact, there was contrary case law in the lower courts. But that school district was on clear notice still that this type of discrimination is unlawful, just based on the text of the statute. So that's not a barrier to finding notice here.
So the dissent in Seoul, I call it Seoul, I don't know if that's the correct pronunciation, but the S-O-U-L-E case out of the Second Circuit,
I believe so.
they note that it's, quote, "It is intentional action in clear violation of Title IX that is intentional discrimination that removes the Pennhurst bar. A policy made in good faith and without clear notice that it violates Title IX is unintentional discrimination and cannot be a basis for damages retrospectively, even if it is ultimately deemed to be unlawful." What's your response to that?
So one thing to clarify, we are not arguing that clear notice never applies to an officially adopted policy. That's not our position. What we are arguing is that the statute and its surrounding legal context puts the districts on clear notice that their policy violates Title IX because it discriminates against girls. So I think I've answered Your Honor's question. The intentional discrimination issue that was discussed in some of the other cases is something that can be resolved under general anti-discrimination law principles. First, Arlington Heights provides a framework for finding that even if it's just disparate impact, it can still support an inference of intentional discrimination. We think that based on the history, all of the background here about Title IX sports being all about providing opportunities for girls, that easily supports an inference of intentional discrimination. Washington would not have adopted policies that undermine the integrity of high school boys football, for example. They just wouldn't have done it if it were boys. But it's girls who are harmed here, and they did it anyway. And at the very least, that shows deliberate indifference. I want to point out that I do not hear the state disputing that it knew of the harm to girls and that it adopted these policies anyway. They dispute whether the deliberate indifference standard applies to a claim
I
like
think they're
this.
disputing that there's harm. So if they're disputing there's harm, then by definition, they're disputing that there was a known harm.
I don't hear them to be disputing that there's some harm to women. Insofar as we're talking about the intent element, they are saying that
They're saying there's no loss
we did it
of
for a different reason.
Right, and they're saying there's no loss of competitiveness, that, they still have access to facilities, to resources, they get to participate. They're saying there's no harm.
They have said that there's no violation of the three-part test. I don't understand them to be disputing the general principle discussed in BPJ that girls do suffer some harm from these. They're
sorry.
saying,
Am I wrong
we can
on
ask
this,
them.
Mr. Coates? Are you
We do
disputing?
dispute that, Your Honor.
Okay, so
Okay.
I think they are. I apologize.
So we do dispute that.
Okay.
Okay, well, thank you for clarifying that. They are arguing that they can't have been deliberate indifferent because this is a formally adopted policy. The Ninth Circuit recognized that a policy can give rise to a claim under a deliberate indifference theory in Karasik. And that's our deliberate indifference theory here. But we also think there's evidence to support an inference of intentional discrimination. This is already a sex-based policy.
I was going to say, on the Karasik one, one of the elements is a known or obvious injury. And that's where, again, it seems to be there's a dispute here, including with the experts. Again, as I've pointed out, there's some wavering there as to whether or not there's an injury or not an obvious injury, I suppose. So that's the Karasik standard, the 5-point standard.
Yes.
So, again, that one, you seem to have a challenge there, quite frankly.
So we think that there's plenty of evidence that this injures girls.
And you're relying on basically BPJ's zero-sum comment. That's what it comes down to, that somehow sports are zero-sum and therefore there's an injury. That's what your reliance is on, basically.
Based for the basic competitive harm, to some degree, yes. But again, BPJ based it on evidence in that record. And our record includes additional evidence specific to wrestling. For instance, Dr. Brown's expert report talks about how in wrestling in particular, even holding a weight class constant, there's male athletic advantage for any biological male, separate from females. And there's also evidence in Dr. Brown's report, although not necessarily in Dr. Carlson's, about puberty. If there were puberty blockers in this case or in a hypothetical case, there's still male advantage on muscle mass, height, all of those sort of inherent athletic advantages for males. So I see that, I guess, the state is not disputing that girls are at an increased risk and that girls don't suffer in athletic advantages, and we think we're likely to succeed in making that showing. I think that's all I have for now, Your Honor.
All right, thank you very much. Let's then move to the last, I think it's the last one. Actually, did you have anything on the harassment issue as well? Or is it?
I'll turn to my colleague
Yeah.
to talk about the Title IX hostile environment and harassment.
Perfect, okay.
Thank you.
Ms. Blake, correct? Yes.
Thank you, Your Honor. So talking,
And if you don't mind bringing that just slightly lower, yeah, thank you.
is this better?
Perfect.
Okay. So when a student alleges that there's been a sexual assault and complains that no one reported it or investigated it like they should have, and then no one investigates the official's own misconduct, no child will feel reasonably safe in that environment. And that's what happened here. The most pressing, the most urgent issue is that KM needs to know where she's going to go to school in 2 weeks. And KM cannot be supervised by the very same coaches and officials who are criminally charged with failing to protect her. The school district's response, its reason why it won't separate her from these coaches and officials, is that it could cost them money to bus her to another school 4 miles away. But they have the bus system in place, a hub and spoke system for other transfer students, gifted programs. They just say that to get her there, they'd have to spend what they estimate as $13,000 to $15,000 of their $17 million transportation budget. So they won't do it. They won't even engage in discussions about ways to meet in the middle, such as to drop her off at mom's school or an alternate bus route at her home. But the school district is required under Title IX to provide supportive measures to a sexual assault complainant well before anyone determines if anyone did anything wrong. And this court has authority under Title IX to separate KM from the hostile environment. This isn't a claim that has anything to do with the gender identity policies. It's just about getting her.
What is the hostile environment, just so I understand this, and where is that found in the actual record that is in support of the preliminary injunction?
Absolutely, let's talk about that. If we could have the permission to show the slides, I think it'd probably help to have some of those record sites up as we go through this question.
No, I don't think I need the record sites. I can easily pull those up, quite frankly. So unless you're quoting direct language, then maybe it might be helpful.
Well, I mean, that's sort of what the slides have, but if we don't need to do that, that's fine. So the standard is 5 factors to show a hostile environment. The first factor is if it's all subject to school's control. That's a gym, that's a school system, that's not in dispute. The second factor to show a hostile environment is whether the action was severe, pervasive, and objectively offensive. And here we have 2 different things that make up that element of a hostile environment claim. The first is the sexual assault, the digital vaginal penetration, and then the second is the official's misconduct in response. The case law is clear that even a single act of sexual assault, a single act of rape, can be sufficiently severe, pervasive, and of course objectively offensive. Importantly, on that point, this court doesn't need to definitively find that the sexual assault for sure happened. The question at this stage is simply whether it is substantially likely that later on at trial, KM can prove that it's more likely than not that it happened. And here it's pretty much undisputed that this physical act happened. Nothing in the record shows it didn't happen. But importantly, that's not all we have under this second factor of the acts giving rise to a hostile environment. When she reported it, no one cared, and that makes her unsafe, and that's the official misconduct. The official misconduct was that they did not promptly report, they did not promptly respond, they did not protect KM on the ground, they took no other corrective action, no other disciplinary action. They did not and have not investigated the official misconduct at all, despite promising to do so. They promised her to investigate the official misconduct. We now know that to be a lie, that for months she thought she was pursuing an investigation to it. Never happened, never was going to happen. And most importantly, the reason we're here today on a preliminary injunction question is that they refuse to separate KM from the coaches who failed to protect her. And even now, the situation persists that they won't let her be away from the people who exercise supervisory authority over her, disciplinary authority over her. That's why she can't wrestle again. The next factor for a hostile environment, the third factor, is that the adults in authority actually knew about the hostile environment. And here we have that in spades. Under Title IX regulations, actual knowledge means any employee who knew.
And I apologize, I just want to make sure I understand this. Going back to the first or the second factor, the harassment in this case is the single act of sexual assault that you're alleging, or is there more?
That's what I'm saying. There's 2 pieces.
Yeah.
A, the sexual assault. B, the official misconduct. Both of them give rise to the hostile environment claim. Both of them are facts and acts that go forth to show this aspect of her Title IX sex discrimination claim.
And the official misconduct being not taking any action between December 6th, I think, and January 30th, is that?
That is one piece of the official misconduct. But as I mentioned, there are other pieces of the official misconduct as well. That they did not otherwise do corrective or disciplinary action, no protective action on the ground, no investigation into the official misconduct despite lying and saying they would investigate it, and then refusing to separate her from this hostile environment.
Is that after January 30th, or we're talking about between January 6th and December 6th and January 30th?
So the failure to report, that duty was triggered at least on December 8th. It was
December
not
8th, sorry.
fulfilled until January 30th. As for the other parts, those are ongoing violations that persist to this day. They still have never investigated the official misconduct. They still have not protected her on the ground. There's still been no corrective disciplinary action, and they still refuse to separate her from these coaches. And that's why she can't continue in sports, and that's why her entire school environment has become hostile. And all of those persist to this day, despite months of complaints and requests that the school issue supportive measures. And that's why we had to ultimately seek relief on preliminary injunction posture. It's actually extraordinary that we're here because in nearly every Title IX situation, it's relatively simple to simply separate a complainant from the people that she was complaining about, give rise to a hostile environment. It's almost routine. And yet here, the school district simply won't let her be separated from this environment, from the adults who failed her.
So the adults in this case are the ones that are creating the hostile environment, just I want to make sure.
So for the 2 parts, A, the sexual assault, that was the responsibility of the male
Right, but
opponent.
the ongoing.
B, the official misconduct, absolutely. Those were the officials and their response. Those are all pieces that give rise to the hostile environment too. As I understand the school district's response, instead of realizing that deliberate indifference is a classic element of the Title IX claim that proves liability, they seem to think that if they continue to be deliberately indifferent to it, it somehow shows that they never knew about anything. And their effort to simply say they didn't have knowledge of this situation is not borne out by everything in the record that shows that this girl has been asking to be transferred to a safe, non-discriminatory environment, and has repeatedly raised the difficulty of going to a school where everybody knows that the school has signaled hostility to her, that refuses to take her sexual assault complaint seriously, that refuses to investigate the official misconduct. That, in and of itself, is why we're here. I'd be happy to speak more to those elements of deliberate indifference as well.
Yeah, so, the basics are, after January 30th, I understand your official position is, hey, look, they did nothing between December 8th and January 30th. After January 30th, though, there is declarations from the other side saying, look, this is everything we've done, here's who we talked to, because there was a criminal investigation going on that, created some delay in interviewing certain individuals, et cetera, et cetera. Excuse me. Now I got to get the cough drop in. So they present, again, declarations saying this is everything we're doing up to date from January 30th until present. And therefore, it seems to be raising a question of fact that, are they in fact creating this hostile environment after January 30th? And so if it's a question of fact, it's hard for me, based on the limited record that I have, to come to a conclusion that there is a likelihood of success, because I just don't know. I don't have enough of the record.
I think if we look at all the facts together, there's ample evidence of a hostile environment. And I think there's sort of two pieces mixed in this. One, is there enough evidence submitted to show the hostile environment? And two, what exactly is a hostile environment? So if we had a situation where it was just a sexual assault and the officials promptly responded and adequately investigated, and simply the question of did it or did it not happen was still pending, that'd be a very different case from what we have today, because then you wouldn't have any official misconduct being acts of the acts giving rise to the hostile environment as well. So here we don't just have the opponent as a respondent, as it were. We also have the officials themselves who had a clearly unreasonable response to the assault. And because of that, those acts have created the hostile environment. I mean, just think about this. You have a 15-year-old girl who complains to her coaches, her principal, everybody, that there was a sexual assault. They don't report it for 2 months. They then say, oh, but you know what, we're gonna investigate the official's misconduct here. They lie to her about that. They never do that. And all the meantime, she is saying that it's...
I mean, let's be honest, they dispute it was a sexual assault. I mean, they dispute that. They say to the effect, hey, rightfully or wrongfully, this is a known risk when you play, or not play, participate in wrestling, that it's not unheard of. Obviously, it's not condoned. It's not something that people are allowed to do technically, but they say that's not, at least their belief is not that it's a sexual assault in the way that many people think a sexual assault normally occurs, because it's potentially part of wrestling, that sometimes people are grabbing each other in different places, and certain things sometimes happen when they're not supposed to, and so they dispute that it's actually a sexual assault as you would define it.
Right, and there's a few different responses that are important to that point. First of all, the standard in Title IX is actual knowledge of the facts, not whether the facts as alleged would constitute sexual assault under federal or state law.
Well, they dispute that as well, because they say that email that was sent on December 8th, at least if you read it, doesn't actually say, I'm complaining about a sexual assault. I'm informing you, rather than saying I'm informing you of, potentially a penalty that occurred during this match.
So if I can separate, the two issues are wrapped up in there. One is what is the standard for actual knowledge under Title IX? And then the second issue is whether this is, as the principal so callously put it, quote, just wrestling. So if I can take the first question first, what is the actual knowledge standard? The actual knowledge standard is whether digital vaginal penetration occurred. The Supreme Court and Ninth Circuit case law is clear that whether in their mind it amounted to something unlawful under federal or state law, whether it amounted to rape or sexual assault is not the question. The question is whether they had knowledge of the actual facts. That's what Gebser said. And that's what the Brown case from the Ninth Circuit said. And it's whether they knew the facts reported, not whether they thought it was a proper or improper move, but whether the fact was reported or not. And the way we know that fact was reported here is you had the email from mom where she complained of the oil check. You then have the video. And then as she texts it to the video, and these are in the first exhibits to the complaint, she says, fingers are in her coochie. That is a clear indication of digital vaginal penetration. And we know they understood it to mean digital vaginal penetration because the principal had a meeting that day with the coach and the athletic coordinator. And later he said, in response to the question, did you understand that to mean digital vaginal penetration? He said, I did. So the actual fact giving rise to this is there. Then we have the second question of what is the relevance of them saying, oh, this is just an improper wrestling move, or as some of the coaches said, happens all the time, gets really uncomfortable. That is not an exoneration, that is a Title IX violation. It is established that if you minimize a sexual assault report and you make it say, well, that's just not a big deal, it happens, that is evidence of failing to take it seriously, and that is evidence of deliberate indifference, not in acting on it. Title IX does not require them to think that this is objectionable in some way. They just need to know the facts, and if they know the facts and they show indifference, then that's where you have the problem under Title IX.
Would this be, in your opinion, a Title IX sexual assault or offense if it had been a biological female that engaged in that conduct and did that?
Absolutely. In fact, when KM was on the wrestling mat, she thought her opponent was female. She got off the...
I think somebody just coughed. I don't think that was intentional.
okay.
So, yeah.
I couldn't really hear the noise. Yes, so when KM got off the mat, she thought she had been wrestling a female, and she was distraught and determined to report what was happening. That's why she was shouting at her mother in the middle of the match, even when she thought it was a female who had engaged in this conduct. It would have been inappropriate regardless. Sexual violence is a Title IX violation, whether it is committed by a male or a female. That's been very clear in anti-discrimination law since the on-call case, and in the Ninth Circuit under the Grabowski decision, it's established that it doesn't matter whether it's a female or a male who's committing the act of sexual violence. It's simply the fact that sexual violence occurs what's relevant. And one thing I would say is that for purpose of federal and state law, there's a similar situation here that's underlying the official misconduct. When official knows of the facts giving rise to a sexual assault, their duty is to appropriately respond. Under state law, that means reporting it within 48 hours. Under federal law, it means not having a clearly unreasonable response. And that's why we have liability under both federal and state law here. These officials knew about the fact that what happened, and rather than act on it, they ignored it. And then when they were revealed to have had this official misconduct, they have refused to investigate the official misconduct or act on it in an appropriate way to remedy the hostile environment. Instead, you have a situation where at any day when KM goes around the hall, she sees these coaches. She can't wrestle under coaches who've shown deliberate indifference to a report of sexual assault. You have school administrators who ignored it as well. You know, in fact, just last night, the school parents were told that there might be an interim athletic coordinator, an interim principal. We don't even know what this means. Perhaps it suggests that some of these officials are now on administrative leave. We have no reason to think they're not going to come back the very next day, in a week, in 2 months. We don't know the situation. And most importantly of all the coaches are still there. She can't wrestle under a situation where the coaches have shown that if she reports sexual assault, they're going to minimize and ignore it. And then if I could go back to Your Honor's question from a moment before about whether in fact this is just wrestling. The Purcell Declaration speaks plainly to that issue, that sexual assault is not a known, expected, customary risk of high school girls wrestling. This kind of act is against the rules of wrestling. It's a flagrant foul. It's incredibly uncommon and unheard of. Our client had been wrestling since age 4. This had never remotely come up. It's not something that she expected, ever saw, would agree to. And so that's part of why to say, oh, this is just wrestling, is in of itself deliberate indifference to the fact that this was a sexual assault. Because no girl should have to consent to sexual assault as the price of getting to play sports. If Title IX means anything, it means that. We haven't talked very much about the fifth factor. I'll just briefly talk about that. That deliberate indifference caused or made her vulnerable to harassment. KM can't wrestle under these coaches. It risks future sexual assault. The officials ignore again. All the while, her opponent remains free to wrestle. And it also makes her more vulnerable to expect her to do so. Moreover, the district's already signaled hostility to her sexual assault complaint, signaled hostility that has been received and understood by officials and peers who in turn have been hostile to her. She's had offensive remarks from peers in the classroom. It's obviously...
Those are not quite in the record. They're in the complaint for sure, but I don't see a declaration from anybody saying, hey, yes, we've seen, or I've personally felt these remarks or anything to that effect.
The complaint was verified, Your Honor, by the client, so that's her swearing to those remarks.
I think it was verified by the mom, if I'm not mistaken.
Both, Your Honor.
Was it? Okay, let me double check that, because maybe I was wrong.
And then mom's supplemental declaration in support of the PI speaks to how she has witnessed the effect of all of this on KM.
Oh, I do see that second signature, sorry. Okay.
And so simply say, the situation we're in today, why the most pressing, the most urgent thing is for KM to be separated from these coaches and officials and to be put in a safe and non-discriminatory environment, is because we have a situation where school is going to start in 2 weeks. KM is already unable to compete in sports. She can't go back to the coaches who have failed to protect her. Separate from the gender identity issues. And we have a situation where at the start of school, the first topic conversation is going to be, hasn't everyone heard that our beloved principal and our beloved athletic coordinator are criminally charged, potentially facing up to a year in prison, and aren't here anymore, and it's all because of her. We know that the teachers and the students have already been hostile to her for getting them, quote, in trouble just when the school was announcing its sham investigation. This hostility is only going to worsen in 2 weeks. The best situation, the situation that would make sense for everybody, is simply a narrow, scalpel-like solution, which is to separate KM from this hostile environment, have a fresh start at a different high school within the same district, just 4 miles away, rather to have this hostile environment persist.
All right, thank you. Let's go ahead and hear from the other side.
Thank you, Your Honor. Kaylin Wett on behalf of the district. I guess I need to separate these issues out because there are now 2 allegations. So referring to the allegations related to a sexual assault. As Your Honor pointed out, the email from the mother didn't say sexual assault, it said oil check. It referred to a wrestling maneuver. And to say that nothing happened at that time is incorrect because indeed, the principal immediately acted on that report, contacted the other coaches at the other school to say this had happened, it's improper, it needs to be addressed. So something happened, and that wasn't unreasonable under the circumstances based on what was known at the time. And that's the standard, what was known at the time. And KMK's mother, Ms. Brown, is a district employee. She has the same training everybody else did. she could have said, this is a sexual assault. I am alleging a sexual assault. I am making a Title IX allegation. She could have filled out the form. She could have made it clear to Principal Smith what she expected to happen, but she did not. The district and Dr. Broby, who's the Title IX coordinator, had no knowledge of any of this at all until January 30th when they received the media inquiry. And upon receipt of that, they immediately acted to determine what it is that this media inquiry is referring to. And then once they figured that out, they immediately launched a Title IX investigation by a neutral third party so that people at the district wouldn't be involved in that. It's a neutral third party doing the investigation. That investigation has not concluded yet. That is ongoing. There were some delays based on the criminal allegations. There were some delays based on both of the respondent and the complainant, and they're working with counsel and whether they could or did not want to be interviewed. So there have been multiple things that have kept that investigation from being concluded by today. But at this point, the report is out, and now the fact finder has to determine whether the respondent did in fact commit or is responsible for sexual harassment. That decision hasn't been made yet, and this forum is not, of course, the forum to make that. The court in Davis said, and that's Davis versus Monroe County Board of Education, that victims of peer harassment do not have any right through Title IX to make, quote, particular remedial demands. And they also affirm that courts should refrain from second-guessing the disciplinary decisions made by school administrators. And here, that's what KMK is asking to do. She's asking to make a particular remedial demand, and she's asking this court to second-guess decisions that have not yet even been made by school administrators. And this is all very premature. To back up, though, what Title IX the investigation is doing is simply determining whether, one, did the respondent more likely than not engage in conduct that constitutes sexual discrimination or harassment, and then two, if so, what is the potential remedy and or sanction. That process continues, that is happening, and that process was started on February 10th, less than 2 weeks after the district had actual knowledge that KMK and Ms. Brown were alleging sexual assault. There's no likelihood of success on the merits of a claim regarding the Title IX allegation of sexual harassment against KMK because it is a very high standard to show deliberate indifference. The court can determine as a matter of law, is what the Supreme Court said in Davis, whether the response was clearly unreasonable in light of known circumstances. And here the district has acted based on the circumstances known at the time.
I'm trying to find, but I think there's language that talks about mere negligence or something else. I forget the phrase that was used.
Right, that's in Karasek case versus Regents of California. They use the language, a negligent, lazy, or careless response will not suffice, and that's at 1105 of that case. Here, the district's response was not negligent, lazy, or careless. It was always responding to the facts known at the time. Sticking with the other students and the potential peer harassment to KMK, as Your Honor pointed out, we don't have facts that KMK has been subject to any ongoing harassment. Again, she has not ever filed a Title IX complaint, nor has her mother. There is no allegations of continuing harassment based on her sex, other than that sexual assault that we're talking about. So the district hasn't had occasion to investigate anything else. Now, KMK did, at the district's request and urging, finally file an HIB complaint, harassment, intimidation, and bullying, with the district. I believe that was filed on August 5th. That complaint doesn't add anything more. In fact, it just inserted the papers from this case to the district, which is insufficient for the district to act. The district needs to know who is participating in the harassment, intimidation, or bullying. What is being said? When is this being said? And so at this point, we're working on arranging an intake with KMK so that those details can be discussed and then investigated. That's ongoing, but I haven't heard a clear allegation that those are based on KMK's sex. She's not being treated differently based on her sex. It sounds like what happened is that KMK went to the media and put herself out there and is
I'm going to cut
experiencing
you
that
off on
attention.
some of this right now, and I apologize because I know we've kind of been going for a while. But I do want to hit upon these points, and I give the other side a chance to talk about, which is, I think you talked about, hey, you know, there's no right for remedial direction at this point in time. And of course, the standard being that, hey, negligent conduct basically doesn't amount to deliberate indifference. I want to hear from the plaintiff on those 2 points.
Okay, and then I still would like to address Principal Smith and those allegations.
Let's do that real quickly because, again, we're running out of time, so I just want to.
I appreciate that. So with Principal Smith, we're kind of in a hard position because, of course, he is a named defendant here, but he has also been criminally charged. And as I'm sure you saw, he is requesting a stay in this case.
Correct.
And those charges came in and definitely impeded our ability to respond for the preliminary injunction because we no longer had his facts to add to this case. But the court in Davis talks about how in Gebser they had already expressly rejected the use of agency principles. And I think here, where we have a named defendant who's been criminally charged, and he is at a school level, he's not at the district level, it's inappropriate to consider him as an official with knowledge as of December 8th. Regarding his response and whether or not he should have made a Title IX report or a mandatory report under any state statutes, I think that's a completely separate issue, and I don't think Title IX addresses those issues. You know, whether he violated school policy, whether he violated state law, that is not subject to the preliminary injunction. That is not an issue here. Of course, the district is investigating that because it could be a potential violation of school policy. But at this point, the district's in a very hard situation because it could be that later on in this case, you decide, well, despite what the court in Davis said as to agency principles, Principal Smith is an agent. And so then that becomes work product, that investigation. It's also a confidential personnel matter. So until these issues are resolved, it's really hard to talk about what's going on in that investigation because it's a separate matter. But regardless, I don't think there's any allegation that Principal Smith's understanding, what he had at the time, was based on any desire to intentionally discriminate against KMK on the basis of her sex. What he was told about was an improper wrestling maneuver. That's what he was acting on. He wasn't acting on, you know, this happened in girls wrestling or boys wrestling. He wasn't acting on anything like that. He was acting on what he was told at the time and responded to that. And the other wrestler is not at KMK's school. So this idea that she should be separated from the respondent, well, she already is separated from the respondent is not there. As far as coaches protecting her, I'm not sure any coach, if indeed this is sexual assault, can prevent sexual assault from occurring in the moment. So that's a hard issue to respond to as well. There are rules, there are policies, there are violations, and there are penalties in wrestling, I would assume. But in the moment, these things happen, and as the prosecutor determined, there's consent to touching. And nobody watching the video, nobody at that match saw any clear sexual assault happening. So I don't understand the failure to protect. After it's reported and after the school understands those are the allegations, there is an investigation. And of course, KMK is entitled to supportive measures pending the investigation. But the supportive measures she is asked for are not all things that the district can provide. So the district granted her request that her exam not be proctored by one of these coaches. It could provide that. But the district can't transfer every single student who makes an allegation to some other school and then pay for busing of that student. That would be an unworkable system. And I do want to touch slightly on, you know, the remaining things that plaintiff's counsel was asking for at the beginning, that the district should just be required to match KMK to cisgender athletes.
And I'm going to stop you there because I don't know if I need to hear that at this point in
Okay.
time. So thank you very much.
Thank you, Your Honor.
All right, let's hear one more time from Ms. Blake. Yes, Ms. Blake. And specifically, I know we're running out of time. It's actually 12 o'clock now, so I don't want to go too much longer, quite frankly, because it's 12 and I don't want to put my staff at issue here. Two things. The comment about, hey, there's no right to make remedial or take remedial action at this point in time based on this type of claim. And then the other thing is the standard for deliberate indifference, you know, the Ninth Circuit has said it's pretty high. Negligent, lazy, or careless response will not suffice. And so the question in my mind is, does this constitute negligent, lazy, or careless, assuming that it is a report of sexual assault? Is that all it is versus deliberate indifference, unreasonable action? And is that a question of fact?
Right, so the standard is deliberate indifference. And the way the Ninth Circuit has talked about it is what you need to show is an official decision not to remedy the discrimination. So if you had a situation where they were merely negligent, lazy, or careless, in theory, that might not amount to an intentional decision not to remedy the discrimination. That's what deliberate indifference requires. But here we have a situation where it is far more than they were negligent, lazy, and careless. We have evidence that shows it was an intentional decision not to remedy the discrimination. And that's because as we march through the factors, they have actual knowledge of the assault and the misconduct. They were then deliberately indifferent to it. They've received complaint after complaint, done nothing, and it has now left her more vulnerable to it. So in the specific sense, no, we're not required to have a specific remedial action as such. So for example, if they were able to separate KM from this environment in a way other than transfer, we think transfer is the most narrow, sensible way to do this, we would welcome if they could figure out a way to separate her from the coaches who have been engaged in this misconduct, from all of the other officials who are part up and down the administration of that, from any of the peers who've been hostile and harassing her as well. Frankly, that's probably far more intrusive than what we suggest is that for KM to be separated herself. So when they say you're not entitled to a particular remedial action, doesn't mean you're not entitled to any remedial action. They have to have a response. It cannot be a clearly unreasonable response. They're required to offer supportive measures. They're required not to have a hostile environment. And the fact that they've come back with no response, no supportive measure whatsoever to separate KM, that's the problem here. That's why we have the deliberate indifference. They have not offered any other alternate supportive measure that could protect her. And moreover, the supportive measure to separate her from this environment does not depend on the outcome of Principal Smith's criminal prosecution either. Because you have the same coaches still in place, you have the entire apparatus. He could come back from what we think is administrative leave at any point in time. It doesn't depend on that. To separate KM from this unsafe, discriminatory environment of sexual, a Title IX hostile environment, just doesn't need the outcome there. And I'll just pause there because I just know I said quite a lot all at once.
Yeah, no, again, those were the two issues I wanted you to address because, again, I'm going to cut this off at this point. Is there something remaining, something that you feel you really need to expand upon? Happy to give you that opportunity, but otherwise, I think we've heard quite a bit from both sides, and obviously we've got the briefing, which is extensive. So is there one last thing that you think you want to just hit on, just to make sure that it's fresh in my mind as we're drafting the decision here?
Sure. I go back to the Title IX standard in this situation. It is far too late in the day, 3 decades on, to say that a hostile environment indifference to sexual violence does not constitute a Title IX violation. I understood the district to say that this was not treating her differently on the basis of sex and thus is not a Title IX violation. We have a long line of Supreme Court cases, Davis, Gebster, Jackson, over 3 decades, and a wealth of Ninth Circuit cases that says when you have sexual violence, that is sex discrimination under Title IX. And here they had actual knowledge of the facts of sexual violence. Principal Smith's already given that information. It's already an exhibit in our reply brief that he knew of those facts. We also have information from Dr. Broby himself where that he is aware of the sexual violence complaint. He was also aware of the misconduct, the failure to report and respond promptly. Those were his words. He promised an investigation into both. To this day, there's never been an investigation into the official misconduct, and there's never been any actual on-the-ground protection for Cam. There's only been indifference and hostility as we go forward. And I don't hear them even now promising anything on the record. There's no evidence that they're actually investigating the official misconduct at all. We have pleaded for months for them to do so. We thought they were going to do so. They then, in their own official investigator report, said that's not within the scope of the investigation. That's also attached as an exhibit in the reply brief, because we just learned about that the day before the reply brief was going to be filed. That investigation hasn't actually happened. And what we have here is something that's far more negligent, lazy, and careless. We have deliberate indifference. We have intent. They promised to investigate the official misconduct. They knew about it, and that turned out to just not be true. They still haven't done anything about it. And at this point, that meets the deliberate indifference standard in spades with all the different problems that they've had here.
All right, thank you, Ms. Blake. Thank you, everyone, for your presentations today, and I appreciate you being here and obviously advocating for the interest of your individual clients. As I mentioned at the beginning, I know these issues really bring out some serious emotion in individuals, and obviously, especially when there's, conduct that is argued and debated as to, possible sexual assault. Certainly, I think everybody has an interest in trying to find and do what's right. With that, I have to say there are some challenges. Just quite frankly, I think, identifying some of the issues with the record on some of the claims, there are some challenges there. I'm going to work on trying to draft an order, hopefully as soon as possible, but, there's a lot of issues that have been raised, and so it might be a lengthy order that we're trying to put together, and we'll get a decision. I will go back and look at that deliberate indifference issue on that last claim more thoroughly to make sure I understand exactly all those issues. But we'll try to get you a decision as soon as we can. I know we're on a short timeline, but we're gonna try to get a decision out as soon as possible. That doesn't mean I'm guaranteeing anything, though, right now. That just means I'm going to work as hard as I can to get you a decision. So, okay, thank you very much. I appreciate all your time and being here. Thank you. And feel free to take your time. I'm going to gather my belongings here, so do whatever you need to do. Yes. Yeah, I know. We won't need it, so yeah.
I probably didn't need to do this, but, it gave me like some mental comfort to just have it there.
Yes.
I'm so, yeah, I'm gonna get your, membership first. It's like, that's a lot. But if you have it. Yeah. This is my first in-person PI. But I did stuff like during COVID.
No, I
First, yeah, that was like a little. All right, I think that's it. All right. Yeah, so
Half an hour and we leave.
Nice to meet y'all. Yeah, I'll meet you. I'm Kelly, Sweeney. Nice to meet you too.
Okay, all right.
Thanks very much.
Thank you.
How did we have those in there to start? What? How did we have them in there to start?
Well, what happened is there's been some revised binders made a comment I won't repeat.
So no one knows.
I'm gonna run to the restroom real quick.
Yeah. I think it's pretty flat. Yeah. Okay, don't forget your backpack. Thank you both so much.
Thank you.
Much for me. It is Gucci, Michael. Me too.
I didn't want to put water in there, so I just dumped it.
Oh, thank you. Everything's changing. Oh. Yeah, no, it's really good. That's all that. Friday's getting completely wiped out if you were here. Thursday afternoon is completely wiped out. So no 3 o'clock Zoom? Correct, and no Zooms in the morning. Okay, which is 10 o'clock Zoom. Yeah, which is gonna be like 2 hours, so. Yeah, I saw that. Friday's gone. Correct. Oh, it's getting moved. Getting moved to. His sister and this morning. Oh. And so he's wiping everything. So that's good. So that's what I've been doing this whole hearing, is contacting people like, hey. And I just don't have it done yet, so that's, but I will send out a new calendar. Oh, no, it's fine. And then I appreciate the heads up. Emily has failed to add, we have a Zoom tomorrow morning, and I looked in the calendar, and I let her and Chris know, Chris Rodriguez, but she hasn't appointed or assigned a reporter yet, and her, so, I don't know who it'll be, but. Okay, 10 o'clock Zoom.